Thank you, Mr. Speaker. Honourable members, I'm grateful for the opportunity to speak on Bill C-10, the Safer Streets and Communities Act. I welcome all of the proposals in this bill. I believe that their enactment, both individually and collectively, will make a significant contribution to safeguard all communities across Canada. I will first address the impact for victims of violent crime. In my riding of Etobicoke Centre, there is a family named Cikovic. The parents are Vesna and Dvorin. Vesna is a piano teacher and Dvorin works at CBC Radio. Their son Boris attended high school in Etobicoke at Scarlet Heights. The Cikovics were refugees from war-torn Sarajevo, with Boris arriving in Canada as an infant. This family worked to escape the horrors of a war where former neighbours preyed upon each other and visited atrocities upon each other in every form imaginable. The family settled in Canada, grateful for the new start that they had and grateful for the opportunities that Canada had provided their son. As Boris grew up in Canada, he became the all-Canadian kid, an athlete and gifted hockey player, a leader on the ice, helping less skilled players score and achieve rather than allowing his own talent to dominate. He mentored his teammates. At so young an age, he showed maturity and a wisdom that was returned by his large circle of friends through great affection and strong bonds that developed in elementary school and endured through high school and what would have appeared to be beyond into university and throughout life. Boris was a leader and one that this close circle rallied around. He was a natural and his future appeared limitless. Then, Mr. Speaker, on a night in 2008, Boris and his friends were transiting a local park, were accosted, and he was shot and killed while being robbed of his backpack and valuables. Mr. Speaker, the Cikovics are victims devastated by the tragic loss of their only son, their son who had natural gifts and talents and was on his way to becoming a model Canadian success story. What of the Cikovic family in this? Do they care that Statistics Canada says crime is down, that as the opposite members opposite rather often cite? I asked them that, Mr. Speaker, and their response was a resounding no. I challenge any members opposite to look that family eye and quote that statistic. The Cikovics are not vengeful people, but they are entitled to justice for their son. On the many provisions in Bill C-10, victims of crime will have the ability to present statements at a parole board hearings. If attending the hearing, a victim may comment on the harm or damage resulting from the offence and its continuing impact, including concerns for his or her safety and the possible release of the offender. Even if the victim does not attend, the parole board may authorize presentation of the statement in an alternative format. Also authorized to present a statement are persons described who were harmed or suffered a loss due to the act of the offender. This includes any safety concerns and concerns regarding the offender's potential release. This provision provides victims with empowerment and a role in the corrections process. Other areas include the elimination of pardons for violent crime and measures that protect the public from violent and repeat young offenders. Mr. Speaker, today I speak for a family that has been tragically victimized, and I speak in the name of Boris Cikovic, who can no longer speak for himself, but today in this House, Mr. Speaker, his voice is heard. I will focus my remaining remarks on Bill C-10's proposals addressing child sexual exploitation and violent crimes in Part 2 of this bill. As members will know, these proposals were originally introduced as Bill C-54, the Protecting Children from Sexual Predators Act, and with all-party support had been passed by this chamber in the last Parliament. Bill C-10 reintroduced these proposals with some additional sentencing enhancements that are consistent with and reflect the overall objectives of these reforms. Part 2 seeks to better protect children and youth from sexual predators in two ways. First, by proposing sentencing enhancements to ensure that all sexual offences involving child victims are consistently and strongly condemned. Second, by creating new offences and measures to prevent the commission of a child sexual offence. Mr. Speaker, Bill C-10 has been reported back to the House of Commons after having been thoroughly studied by the Standing Committee on Justice and Human Rights, without any amendments to its child sexual exploitations reforms. Indeed, Part 2's proposals received strong support by witnesses appearing before the Justice Committee, including the Canadian Association of Chiefs of Police, the Canadian Police Association, the Kids Internet Safety Alliance, KINSA, as well as the Minister of Justice and Attorney General from New Brunswick, who said, "I believe strongly that crimes against children deserve strong sentencing. We believe the changes proposed in this crime bill will make it possible to achieve that objective." I couldn't agree more. Bill C-10 proposes to enhance the sentencing or penalties for sexual offenders involving child victims in two ways. It proposes to impose 7 new and 9 higher mandatory minimum penalties, as well as higher maximum penalties for 4 child-specific sexual offences. These amendments are needed because currently the Criminal Code only imposes MMPs in 12 child-specific sexual offences and none at all in the general sexual offences where the victim is a child. And for those offences that already impose MMPs, these are inconsistent and or simply inadequate. The effect of imposing MMPs in only some but not all sexual offences sends an inconsistent message that not all child sexual offences are serious and perhaps even that some child sexual assault victims are less victims than others. Imposing inconsistent and inadequate MMPs is equally problematic. For example, currently the Criminal Code imposes a mandatory minimum penalty for 45 days for the offence of sexual interference with a child, even though the maximum penalty or indictment is 10 years. Bill C-10 proposes to fix this by increasing this MMP to 1 year. To my mind, and I think to all of us here, the current inconsistent and inadequate approach to sentencing in child sexual abuse cases is wrong. Who among us does not agree that children are the most vulnerable in our society and that all children are deserving of equal protection against all forms of child sexual exploitation? As I noted earlier, Bill C-10 also seeks to prevent sexual assault against children. It proposes 2 new offences criminalizing sexual assault against children that police witnesses were particularly against. The first new offence would prohibit anyone from providing sexually explicit material to a young person for the purpose of facilitating the commission of a sexual offence against that young person. Child sex offenders often use adult pornographic material to groom their victims, for example, to lower their victims' sexual inhibitions with a view to making it easier to sexually exploit them. Though any such use of child pornography is already prohibited, this is not the case for adult material. Accordingly, this new offence would fill a gap. The proposed new offence would impose a mandatory minimum penalty consistent with other parts of the bill. The second offence proposed by C-10 would prohibit anyone from using telecommunications to agree or make arrangements with another person to commit a sexual offence against a child. This offence is modelled on the existing luring a child offence of the Criminal Code that prohibits the use of computer system to directly communicate with a child for the purpose of facilitating a sexual offence against that child. However, as the luring a child offence only applies when communication is with the child victim, this new offence closes the gap where the communication is between 2 other persons to facilitate the commission of a sexual offence against a child. This offence will also impose a mandatory minimum penalty. As well, Bill C-10 will impose a condition on convicted child sex offenders or on suspected child sex offenders, a recognizance or peace bond under Section 810.1, prohibiting them from having any unsupervised access to a young person or unsupervised use of the Internet. Preventing a known or suspected child sex offender from having the opportunity and tools to commit a child sexual offence should protect other children from being victimized. Mr. Speaker, I urge all members to support the swift enactment of Bill C-10 so that Canada's children will be protected against sexual exploitation. Thank you, Mr. Speaker.
Questions and comments? Question, commentaire. The Honourable Member for York South Weston.
Thank you, Mr. Speaker. And my heart goes out to the family of Mr. Cikovic that you referred to earlier, and we certainly don't disagree that we on both sides of the House would like to prevent crimes such as this. And I guess that leads me to my question. How does this bill do anything to prevent what happened to the Cikovics from happening again? Could you explain to that for me, please?
The Honourable Member for Etobicoke Centre.
Mr. Speaker, I thank the Honourable Member for his question. It assists in preventing further crimes because mandatory minimum sentences are imposed on a lot of these crimes within Bill C-10, which will add a further deterrent to criminals contemplating perpetrating this form of crime, especially a violent crime in this case. It also allows, if a crime in this case, as it has been committed, is perpetrated, it also allows the victims a form of redress in being able to access the parole system and have an ability to impact on the offender's incarceration.
Questions and comments? The Honourable Member for Charlottetown.
I just want to follow up, Mr. Speaker, on that last answer. The suggestion from the Honourable Member is that mandatory minimum sentence will provide a deterrent. Yet, there is no evidence for this. In fact, there's evidence in the United States to the contrary. My question is whether this member's view of the criminal law is that the right way to go is an eye for an eye and a tooth for a tooth, or does he subscribe to a more enlightened view based on proportionality?
The honourable member for Etobicoke Centre.
Again, Mr. Speaker, I thank the honourable member for his question. And this Bill C-10 is a made in Canada law. It's not a made in the United States law. So we're not looking at them, we're looking at us. And Canadians have given this government a very strong mandate to enact the laws. We made a promise that we would pass Bill C-10 with strong laws involved and making sure that serious offenders are jailed for the appropriate length of time. It also ensures that our victims feel that justice has been rendered. It's not an eye for an eye thing. It's an ability for the victims to be able to redress the crimes that have been perpetrated against them and to ensure that the criminals are incarcerated for an appropriate period of time. Although rehabilitation still happens, it provides comfort to those victims that these criminals will not be released too early and that their rehabilitation will have time to take root, Mr. Speaker. Thank you.
Questions and comments? The honourable member for Fort McMurray, Athabasca.
Thank you, Mr. Chair, and I appreciate the opportunity to ask this member a question. I'd like to congratulate him on the speech, a well-done speech. And indeed, I did listen to the question from the Liberal member opposite, but I had an opportunity to practice criminal law, actually be in the trenches in this kind of situation. And I had a client that received 2 years less a day for sexually assaulting 2 of his daughters over a 7-year period of time. And he was able to do that in a house. And I was ashamed of getting that sentence. I was quite frankly surprised that that sentence was available, first of all. That was about 8 or 9 years ago. But it's still available today, Mr. Chair, and we're taking away that opportunity. And I just want to ask the member, does he think it's reasonable that a person that would do that to his daughters, 2 family members, over any length of time, if at all, is that a reasonable thing to be able to do any time or any punishment in your own home? Is that a reasonable disposition as is allowed today under the Criminal Code?
The honourable member for Etobicoke Centre.
I thank my honourable colleague for the question and his comment. And absolutely it is not a reasonable time, especially, first of all, any offence against a child, whether it's your own child or someone else's, is absolutely reprehensible. However, when they are your own children and they are to feel safe and secure with their parents in their own home, and they don't feel that and they are victimized by their own parents, and then that parent is only sentenced to the absolute minimum possible term, that continues to victimize those children once again, because that individual will be released in 2 years less a day, or less than that even. And that will cause further harm to those children down the road because of psychological impacts and because justice will never have fully been rendered in their case. Thank you, Mr. Speaker.